morning, everyone, or good afternoon, I should say. Welcome. My name is Ashley DeBoard. I am an estate planning attorney and also a business owner, like many of you. Um, so I have been in practice since 2011, and I've um, been the founder and practicing attorney here at Flagstaff Law Group since 2019. Flagstaff Law Group is an estate planning firm serving Northern Arizona in the areas of estate planning, business planning, and elder law. And we are a women-owned and women-led firm with a team of 9. So we have 2 attorneys and then a support team of 7. And I'm just here to talk to you today about estate planning for business owners and what are some of the essential things that business owners need to think about as it relates to planning for the unthinkable. Um, I'd love to share just a little bit about myself and what kind of brings me to this work. So, what has kind of brought me to this work is actually a little bit more of a personal experience that I had many years before I realized that I even wanted to be a lawyer. When I was in my first year of college down at ASU, my own dad passed away, and he had been sick for some time before he passed. And because my sister and I were his next of kin. We were kind of the people to make decisions for him. So when he got sick, he was hospitalized. He was in the ICU and placed on a ventilator. And my sister and I were left to make some very big decisions about his end of life care without really having any clue what his wishes were for those circumstances. And we did the best that we could navigating those questions and making decisions. But as you can imagine, there were about as many people um, with opinions about how that should go as there were people in the waiting room who loved him and really wanted to see a good outcome for him. So, we navigated that as best we could, but it was a very heavy weight to be holding, not really having clarity around what his wishes were. And unfortunately, after he passed, there was some additional, difficulty and conflict, and just trying to like pick up those pieces and figure out how to navigate that. So it was really kind of this early experience for me of navigating my own family's experience with somebody becoming incapacitated and dying without a plan or a clear roadmap that really clarified my desire to help other folks get a good plan in place to make things as easy as possible for their loved ones. So that's just a little bit about me and what kind of brings me to this work. Okay, so estate planning, isn't really just about money or transferring assets. That's certainly one piece of it. But it's also about really preventing family and business conflicts and disasters. So business owners can face an even bigger challenge when we don't plan ahead. And it can often lead to disruptions in business or collapses in our business. And I often see really the number one mistake that business owners make is that they assume that their spouse or their kids or their business partners can just step in and handle things when something happens to them. But the reality is that that doesn't happen automatically, and many people face big disruptions when they don't have a clear plan in place. Without any kind of legally enforceable plan, sometimes banks will freeze bank accounts, personal and business bank accounts. For business owners, this can be very difficult because it might mean that their employees won't get paid, their bills won't get paid, and maybe their partners or their heirs could be forced into a court process or some sort of conflict. So I'm going to explore some of these concepts today using a little bit of storytelling, and I'll share with you a few case studies, and then I'll talk about some key concepts like probate and planning solutions like wills and trusts and how those actually work together. And then I'll definitely cover some questions at the end. So I'm going to start by telling you about Mark. So, and by the way, all of the stories that I'm telling, these are not real people. So I'm telling you a fictional story, but based on many true stories that are kind of a composite of many of the situations that I've encountered as an estate planning attorney over the years. Um, so I'm going to tell you about Mark, and he was a contractor. He owned a pretty thriving contracting business, and he had built it up such that he had employees, he had various customers, many projects running all at once. And Mark was really the one that held it all together. So he was the only one who really knew how everything worked in his business. So I know that for a number of years that felt true for me. And so this was the case for Mark, and he really had everything running in his head, from payroll systems to his vendor relationships to the project timelines on his contracting business. And then one day, Mark had a massive stroke. He had a stroke and he was placed into a medically induced coma. So he was incapacitated and he could not manage all of the things that he had running. So the problem was that no one else had access to his bank accounts. Payroll was not processed, and the employees didn't get paid. So they started to leave. All these critical business logins and systems were all located inside of Mark's head, and his wife and his employees couldn't access his email, information for invoices or client contracts. Um, Not surprisingly, this was very frustrating for Mark's customers and his vendors who were supplying for him, and they were kind of left in the dark. Um, there wasn't any way to really get out good communication. Jobs stalled out, clients canceled contracts. And because his wife was not a co-owner, she couldn't legally make decisions on behalf of the business or access any of the key accounts or lines of credit to keep everything running. So within a number of weeks, everything was really collapsing. His family had to go to court just to get access to the business accounts. And by the time they had the authority in place, the damage was already done. His business, something he had spent years building, really began unraveling. And for Mark, this could have been avoided with some more clear business succession planning, getting a power of attorney in place, and making sure that he was setting up clear access to systems and logins and financials for a trusted person like his wife or somebody else. So having a roadmap in Mark's case, and in the case for many business owners, it isn't just smart, it's really necessary to keep the business alive if something happens to us. So Mark's business really collapsed because no one knew where to go when he became incapacitated. And in just a moment, I'm going to talk about what happens when a business owner passes away suddenly without a clear plan. So that's the next case study that we'll talk about. So, for those of you that are business owners, maybe you'd consider sharing how many of you feel really confident that if something happened today, everyone would know where to find things and how to access them, and that would be really easy for them to access. And I think this is the case for many of us as business owners because it's so common that we're just kind of focused on the next thing, right? And we're just trying to get the next thing in place. And we don't always take the time to go back and make sure that we've got the solid foundation. And that was certainly the case for Mark. He imagined that it would just be kind of easy to figure out. And I'm sure he never imagined that everything would come to a screeching halt because he was kind of holding the keys to everything. So I want to introduce you to Sarah next. So Sarah, she's also a business owner. She built a very successful $1 million a year coaching company, and she had a very loyal client base. Sarah did not ever set up an estate plan. So she assumed that since she was the sole owner, her family would just kind of inherit the business automatically. She imagined that what she was building was really increasing value, and that someday she'd be able to maybe hand that off to her children or sell the business and have her children benefit from the value of the business she built. But she just never got around to formalizing a plan. So she was pretty young, um, in her late 40s, and she assumed that she had plenty of time. But what actually happened is that, Sarah passed away unexpectedly. And when that occurred, the business bank accounts were frozen because they were just in her name alone. And her family had to go through a probate court process for over a year before they could even really get at those funds and access them. Sarah also had employees for her company, and all of them had to find new jobs. The business shut down before probate was completed. So by the time her children were able to really gain control, her loyal clients, they had moved on, and the business was worth a lot less than when she was living. Now, if Sarah had set something up like a trust, her business would have been able to pretty seamlessly transfer to her chosen successor without any sort of really expensive and time-consuming court involvement in probate. And it would have been able to transfer without delays and without a huge financial loss to the company. So Sarah's family really lost this thriving business because she didn't have any kind of a clear plan or a trust in place. But sometimes, even if a business is financially stable, conflicts can still destroy the business or its operations. And that's what I want to talk about next in just one final case study that we're going to look at. So finally, I want to introduce you to Shelley and Amy. So Shelley and Amy were 50-50 business partners, and they had a really thriving real estate investment company. And when Shelley passed away, so Shelley passes away, she has an adult son whose name is Joey, who is 21. And Joey ultimately inherited her 50% ownership in the business. So the problem was that Joey, as a 21-year-old, didn't have any experience running a business, and he wanted a payout of his mother's share. Amy couldn't afford to buy Joey out. She couldn't afford to buy Joey's share outright. They didn't have any kind of insurance policies in place between the two owners that would have made that easy. And Joey started, as a co-owner, making some decisions around the operations of the business, even though he didn't really understand the business. And he got in a bit of trouble. He distributed funds to himself without Amy's permission, leaving insufficient funds in the account to be able to cover all of the expenses associated with the operations. Eventually, the business had to be sold just to be able to settle this ownership dynamic and this ownership dispute between Joey and the other remaining business partner. And frankly, this does happen quite frequently where there's no what we call buy-sell agreement in place. So no kind of operating agreement, no buy-sell agreement that clarifies how one owner's share will be passed to either a surviving owner or to other people to inherit. And who gets to be in control and how decisions are made or how the buyout is amount is determined. And so when that happens, oftentimes people find themselves landing in court in order to resolve those disputes. So in this case, what would have been really helpful is a simple agreement and maybe some thoughtful insurance to have allowed Amy to buy out Shelley's half of the business with a preset plan. And this would have helped to avoid a lot of conflict and would also probably have preserved the business and the operations if that's what Amy wanted to continue to do. So at this point, I want to take a step back and talk about how assets, especially business assets, are handled when someone becomes incapacitated or when someone passes away, and what actually happens from a legal perspective. So that kind of brings us to an important topic that I've mentioned a couple times, which is the topic of probate. So probate generally refers to the legal court process that assets may need to pass through when we die with assets in our personal name that are not going to a surviving joint owner or a designated beneficiary. And if you think about it, that makes sense, right? Because when we're alive, we can sign our assets over all day long. We just sign on the dotted line. But when we're deceased, we can't physically do that. And so the legal court process is really designed to make sure what we have goes to the right people while also giving notice along the way to anybody else that we might owe money to at the time of our death, or anybody else who might have an interest in our estate who should get notice. And generally, what that looks like is somebody is going to have to step forward and open up a probate court case to be appointed by a judge as your executor. In Arizona, we call that a personal representative, but it's basically the person who's going to figure out everything that you have, where it's located and what it's worth, and essentially marshal those assets through the legal court process. They're going to pay all of your final bills and expenses, and then whatever's left over will go to your heirs, or if you have a will, to designated beneficiaries in your will. And the person who will step forward typically is going to be dictated by your will, if you have one. If you don't have a will, that person, who that can be, will be dictated by Arizona law if you live in Arizona. So it'll be dictated by default laws. And the law typically is allowing your closest family member to step forward to do that for you. So in the case of a married couple, it would be your spouse if they're available. If your spouse is not available, or maybe they've passed at the same time as you, then we would look to see, do you have any adult children? In which case they could step forward. If you don't have any adult children, but you have living parents, it would be parents. And if you, don't have parents available, then it could be siblings, and kind of outward from there, right? So who are your closest family members? And for some people that works fine, that default, but for many folks, their family relationships are such that the people who would be first in line are maybe not their first choice. Or they might have relationships where maybe one person in a group would be fine, but another person in that same group would not be somebody they would ever want to handle things. And they don't want to leave it to chance that that person could step in and handle things for them. So that's a little bit about the process. Now, some of you may have heard a lot of people want to avoid probate if they can, and you might be wondering, what is the reason why people want to avoid probate? Well, generally, probate is expensive. It is really time consuming. Accounts are frozen when they are in the probate process, and assets are frozen, and it's a totally public process. So it's not really the best process to safeguard privacy, which is especially a concern for business owners because there are probably a lot of details related to the business or its operations that we don't want to necessarily have as part of a public record, right? So on average in Arizona, it takes about 9 to 18 months for assets to move through a probate court process. And why that can be especially challenging is because assets are going to be frozen when they're in that process. And if they're frozen, that means the money can't be accessed to pay for all the things that cost money right after we die. So things like paying for a burial or a cremation or a funeral, paying a mortgage, paying for childcare, making sure the business expenses continue to get paid. Even hiring a lawyer to open up a probate case to unlock those assets, all of that costs money. And people often find that somebody else, probably like another family member, will have to come out of pocket and cover them and cover their estate and pay for those things up front, hoping that later on in the probate process they can get reimbursed after all the final debts and expenses have been paid. So that's not an ideal situation. Of course, anytime we're in court, it costs quite a lot, and the cost can be variable. A good rule of thumb on average is about 3% of the value of the probate estate are kind of the costs of things going through probate, but sometimes that can be much higher, especially when there's complexity with the types of assets. So things like real estate and business interests tend to bring more cost and complexity to solving that in a probate court process. Um, with probate, generally, everything in the court record is a matter of public record, and we have an obligation to publish in the newspaper to let potential creditors know that they have this window of time to bring a claim to get paid before what's left goes to the heirs of the decedent. And because of that, it does kind of shine a spotlight on that person and their estate and maybe the people that they care about that are coming into the inheritance. And some people just don't like that private information to be publicly available. They might worry that their family would be kind of vulnerable or a mark for other folks that don't have good intentions for them. So that's a little bit about probate and what that involves, what that entails in Arizona. Um, For business owners, I would say probate can be especially devastating because while everything is tied up in court, your business often can't operate and revenue is typically lost. If you have employees or you have clients that are depending on you or your business, this can sometimes mean a complete shutdown. And I'll say the best way to avoid probate and keeping your business running smoothly is through proper advanced planning. And we're going to talk a little bit about some tools that make that possible. But before I do that, I want to kind of explain also a common misconception that I encounter, which is that many people assume that if you have a will, that's all you need to avoid probate. And many people are surprised to learn that a will does not control all of your assets. So even if you have a will saying, this is what happens to my assets, sometimes your will is overridden by other situations. So at the end of the day, there's two things that really override a will. And those two things are when you own some assets jointly with another person and when you have assets that have a designated beneficiary on them. So I'll talk about that in just a second here. Um, okay. So I like to use an analogy of thinking about this in terms of three different buckets. So if we imagine our estate as everything that we own during our life and at the time of our death, whether that's a business or a house or bank accounts, investment accounts, retirement accounts, vehicles, all of these sorts of items that we might own at the time of our death. And if we're imagining the pathway of how those assets get to the people entitled to receive them, we kind of have three different buckets or pathways that these assets can travel through. So the first bucket would be when we own assets jointly with another person. And I would say 9 times out of 10, when you own something jointly with another person, it will pass to the surviving joint owner and it will pass to them directly and immediately, and it will totally bypass the probate court process. Now, I put an asterisk here because there are some nuances when it comes to businesses and real estate. Typically, with businesses, unless they're set up very specifically to do this, typically one business owner's interest is not going to automatically pass to the surviving joint business owner. And we saw that in the last scenario that I talked about. So typically, in order for that to be accomplished, we need to have the right setup with the business, both in how it's formed and how an operating agreement is written for that to be true. So businesses, I think, are a big exception there. And then And then with real estate, we have to look very closely at the title to make sure that as it reads, for the joint owners, we have to know if it says with right of survivorship. And if it has right of survivorship, then that's the case that the surviving joint owner would receive the property. But everything else, like bank accounts or vehicles or other things, typically if you have a joint owner, it's going to pass to the surviving joint owner. And that can work really well, especially for married couples, right? Because if they own everything jointly, we may not need to see a probate at the death of the first spouse. And I will say that sometimes that pathway can break down very easily too when something happens to both of the joint owners at the same time. So if you own your house jointly with your spouse and then you're involved in some kind of accident where you both pass away, it's very possible that that asset can be pulled into probate unexpectedly. So that's one pathway. The next pathway is going to be beneficiary designations. And I'm willing to bet some of you may have beneficiaries designated on certain assets. The most common examples I see are things like retirement accounts and life insurance policies, because when we set those up, we're kind of proactively prompted to nominate beneficiaries on those assets. So if those assets pass, they will pass totally outside of the probate court process and go to the designated beneficiary. And that can actually work very smoothly as long as the beneficiaries are of a suitable age and are not vulnerable and in need of protection, or as long as the types of assets pass smoothly to beneficiaries. So let me break that down a little bit. So when we have minor children, um, they are not able to directly inherit those types of assets as a designated beneficiary without a court intervening. So if they're minors, there's going to be a court process that they're immediately thrown into, which is called a conservatorship, where a court would appoint a financial guardian for the child for that money until the child reaches age 18. Then at 18, whatever's left just goes to them outright and in their laps with no protections in place. So that's not ideal for minors. Court is expensive and time consuming, and it doesn't give any protection beyond age 18. So when we have minors, we don't want to leave things to them by beneficiary designation typically. Similarly, if we have young adults or vulnerable adults with special needs, we wouldn't want to do a beneficiary designation because that outright distribution doesn't properly protect them or protect their government benefits in the case of somebody with special needs. Then there's also just some types of assets that don't share very well, right? So if you think about real estate or business interests and you have multiple people that you want to inherit, they may not be able to share a piece of real estate or a business very easily. And they may not want to be co-owners on that type of real estate or business because it might require a level of agreement or cooperation that those multiple beneficiaries can't reach. So that can often be fertile ground for conflict and a lot of confusion. So that's a little bit about the beneficiary bucket. It's important to just know it's an outright and immediate transfer of the assets to the beneficiary and doesn't come with any kind of control or protections for the beneficiary. And then finally, if we kind of take the assets through the joint ownership bucket and the beneficiary bucket and we kind of set those aside, whatever lands in the third and final bucket, we can kind of think of that as the final one that's catching everything else that's left over. That is the probate bucket. And that is the one that passes according to your will. And that is the bucket that has to go through that full court process that we discussed. Now, there is a minimum threshold, and in Arizona, just updated recently to be a threshold of $200,000. So for very small estates with less than $200,000 in the probate bucket, we're not going to need to do a full probate process. There's a more streamlined process called small estate administration. But for anything above the 200,000 mark, collectively, we're going to see that full court process that I described. Okay. So generally, a very common misconception that I hear is that a will is all you need. If you have a will, you can avoid probate. And as I've kind of described, a will doesn't cover all your assets, and the will is not the tool used to avoid probate. So, a will is actually a directive for probate. So, if you have a will, it's very important, but it doesn't avoid probate, it directs how probate will go. A will really has two or three very important jobs. It is going to identify who is your executor, who's going to marshal all your assets through the court process. It's going to identify who are your beneficiaries who will inherit what's left over in the probate bucket at the end of probate once all the bills are paid. And then if you have minor children, it has one more important job, which is to identify who will raise your minor children if you are not able to do so. So that's really the job of a will, and it's not to avoid probate, it is there to direct probate. So the other tool that we commonly use if we're trying to avoid the probate bucket is we try to use a trust. And the type of trust I'm talking about here to avoid probate is a revocable living trust. And this is a tool that really keeps your business and your personal assets out of court and provides protection for you while you're alive and after you're deceased. So it basically creates privacy because everything can happen outside of that public court process. And that's really helpful for business owners because it keeps all the key details about your assets and your business outside of the court record. So with a trust, your designated successor, they can step in immediately to manage your business without waiting for probate court approval. And a will, unlike a trust, doesn't protect your business from probate or from disputes, but a trust would allow more seamless business continuity and avoid court involvement. And I'd like to kind of talk to you a little bit about how a trust actually works to avoid probate. And I like to use the analogy of a trust being a little bit like a shopping cart that we take with us through the grocery store. So if you can imagine walking through a grocery store and you're just carrying all your groceries around in your arms, that's a lot like walking through life owning all of our assets in our personal name. And there's not a rule against it, but if you're walking through the grocery store and you're carrying around all your groceries in your arms and you slip and fall on a puddle in aisle 5 and you go down and the groceries go flying and they spill all over the floor, somebody else has got to come in and mop that up. And that's a lot like dying with assets in our personal name that spill into a messy probate that somebody else has got to come in and clean up for us. Whereas if we get a revocable living trust, it's like having a shopping cart that we can put our groceries in as we're taking it through the grocery store. And importantly, that cart, it stays standing even if we go down. It has longevity beyond us. So as we're walking down that aisle and we're pushing our cart, if we go down on that same puddle and we go down, the cart stays standing. And any of the groceries inside are really protected from that messy probate spill. They're not spilling all over the aisle. So initially, when we set up a trust, if we're an individual, we might just have our own trust, or if we're married, we might have a joint shopping cart with another spouse, and we might be pushing that cart along, and we would it would really be treated as an extension of us. We would be in charge of it, and we would be able to put our groceries in and pull them out and use our groceries inside however we want. We can set up instructions on the cart and even change those instructions over the years as things change. And we might set up those instructions to say, this is my cart and I am pushing it and I am in charge of everything. But if something happens to me and I can't push my cart anymore, these are the people that I trust very most in the world to take the handles and keep on pushing and managing what's inside my cart. That role is called a successor trustee. And if you're still alive, that person's job would be to reach inside and use the groceries in the cart to take care of you or your spouse or your dependents like children. And if you're deceased, there would be some different instructions on the cart where you could say, I want these groceries to go to these people on this timeline and in this manner. And that can be really helpful, especially if you want to make sure a home gets sold or a business gets sold or preserved in some way or passed to a specific person. And when we have minor children, it's very valuable because we can really put another grown-up in charge of those groceries until they reach a more suitable age before they are put in control of them. So we don't have to give it to them at age 18. We can give them more time. So that's a little bit about a trust and how it works. Here's the really important thing, though, that I have to mention, which is that when we have a trust or when we have a shopping cart, we actually have to get the groceries in the shopping cart for this game plan to work. So we can't be carrying around all our groceries in our arms and pushing around an empty shopping cart because the groceries in our arms are still very vulnerable. So it really is a two-step process where first you get your shopping cart set up, get all the right instructions on it, and then secondly, you make sure you're getting your groceries inside. So what this looks like for a business owner is typically they're going to update their membership in an LLC or their ownership in a business and transfer it from them personally into their shopping cart, into their trust. And then they probably want to make sure that they update their operating agreement to have language in there that allows their trust to step in and handle things. Um, okay, so now that we've talked a little bit about that, I do want to just kind of speak to something else, just related to I think the misconception that a lot of people hold of, oh, I don't know that I have enough value in my estate or enough wealth or enough assets to really justify doing estate planning. And, you know, I think that is kind of a not a helpful frame because even though estate planning does um, take a bit of an investment. Typically, not doing planning is often much more costly, and the costs are not just financial. So the financial costs are real, and thousands of dollars, sometimes tens and tens of thousands of dollars to have to go through a court process. But also, it's a lot more about indirect costs, right? So the loss of business income, operational disruptions to a business, family conflict and disputes that can really drag on for years. Just the weight of forcing somebody into a complicated and time-consuming court process when they're in the fog of grief and loss. It just adds and augments to that sense of loss and that experience of loss. So, to not do planning does have really extensive costs. And typically the investment in a proper estate plan is far less costly um, than the expense of fixing things later in a court process. So it's something that many business owners don't realize, which is oh, but let me just kind of back up. So yes, in general, it can feel like a lift to take on the process of getting a plan done and getting it done properly, but typically an investment on the front end and that is going to save a lot of time and headache and expense later. And then the other thing that I want to just make mention of that sometimes business owners don't realize is that their estate plan or parts of their estate plan may very well be like a tax deductible write-off. So this is sometimes good to know toward the end of the year, right? If they're trying to get any final deductions before year's end. We're in December, so this is relevant timing to talk about that. The estate plan may very well be tax deductible if it's structured correctly, because there's lots of things that we do in personal estate planning that allow for appropriate business succession planning, right? We will put in place things like powers of attorney that allow people to jump in and be able to make financial decisions without having to go to court and getting appointed by a judge. And that generally prevents a lot of disruption in the business and being able to access accounts. And doing that has a benefit to the business. Similarly, creating a trust and putting a business in the trust creates huge benefit to the business because it allows the business to avoid a probate court process. And you might be doing other business work as well related to an estate plan. So oftentimes people, and I'm not a tax advisor. So obviously talk to your CPA about this, but you might explore being able to deduct some of those expenses and get some tax optimization for investing in an estate plan. Um, so I've talked about a lot of different pieces here. we've discussed some of the different tools involved, some of the challenges of not having an estate plan in place and why estate planning is so critical, especially for business owners. And we talked a little bit about how to get something in place that would prevent some of those issues from happening. I do recommend that if you're going to be doing an estate plan or you're thinking about whether you need an estate plan, I definitely recommend contacting a qualified attorney and working with somebody who's very experienced in this area. A lot of people think the situation can be very simple, but oftentimes it has complexity, and you may just not have visibility on that. And I hope that some of the things I've discussed today have given you more of a frame for that.